Hello and welcome to Legal Briefs, late night crypto edition. Yes, I was laying down in bed, getting ready to sleep, watching Between Two Ferns on YouTube, when ding, I was notified that in the SEC versus Ripple lawsuit, the individual defendants Garlinghouse and Larsen had filed their motions to dismiss the lawsuit letters, and as tired as I was, I couldn't help but take a look, and I read it. I got so excited about it, I had to get up and knock out this vlog. I am such a legal nerd. Sometimes I'm surprised she said yes. So we have what is essentially the outline of a motion to dismiss by Garlinghouse and Larsen, and boy, it is a doozy. Remember, as always, don't take what I say as legal advice. If you need help defending yourself, ask this guy. His name, anyone? Now, if you're British, you do not get to play. Now, he's really your best line of defense. And that's really what a motion to dismiss is. It's your first line of defense to a lawsuit. A lawsuit can basically end in four ways. First, it could end in a settlement. Second, a successful motion to dismiss. Third, in summary judgment where the judge decides the issues. And four, a trial, usually with a jury. Please keep in mind that if the defendant loses this motion, all that means is that the lawsuit has alleged enough facts to continue in the process. You can and you often lose motions to dismiss and end up winning the lawsuit, and I will explain that in a second. So here we have a motion to dismiss, and it's in letter form because the judge, in this case Judge Torres, requires a maximum 4-page letter, and then she will tell the parties when and how to file the actual pleadings itself, something that looks more like a court filing, and look at how much of the 4 pages Attorney Solomon has taken up. Every single space he's used. He must be on Twitter. So this motion to dismiss is being made under Federal Rule 12b-6, and in order to win a motion to dismiss under this rule, you must show that even if all the allegations in the lawsuit are taken as true, even then the lawsuit doesn't show a plausible case. So for example, if the lawsuit alleges that Brad Garlinghouse painted the sky green on January 1st, 2020, for purposes of a motion to dismiss, Brad painted the sky green. Now it's only later in the lawsuit that we can even argue whether he did or he didn't. So let's take a look at the argument the individual defendants are making. The first argument at page 1 is at the bottom, and it's the weakest. And this argument is that the defendant's sale of XRP were not sales of security. And it says, first, the SEC fails to recognize the economic realities of defendants' transactions in XRP, the XRP market, and Ripple's business, each of which exhibit none of the traditional characteristics of an investment contract under the Howey test. And skip down a little bit. Mr. Garlinghouse's XRP sales involved no contract of any kind with the buyers, as his sales were done anonymously over an exchange, nor were the proceeds of Mr. Garlinghouse's sales pooled with other buyers in a common enterprise. Now, this may be a good argument later on in the case, but the reason why I say this is the weakest argument in the motion to dismiss is because I think that the lawsuit is strong enough factually, if everything it says is true, that the judge should make the decision. And that doesn't mean that Garlinghouse or Ripple will lose on this issue at summary judgment. It's two completely different things, a motion to dismiss and summary judgment. I just think that there's enough in the lawsuit to make it past this stage at a motion to dismiss. And as evidence that I am correct, make a note that Ripple did not file a motion to dismiss on this issue. If it was a strong argument at this stage, Ripple would have tried it as well, but it didn't. It answered the complaint. But let's take a look at the second argument, and this is what got me out of bed and outlining this vlog. It's exciting, it's strong, and it's about scienter. Looking at Roman numeral 1, the amended complaint fails to adequately allege scienter, a necessary element of the aiding and abetting claim. The amended complaint purports to allege that Mr. Garlinghouse aided and abetted Ripple's unregistered sales of XRP, while violations of Section 5 do not require a showing of scienter, aiding and abetting does. The SEC has the burden to demonstrate that Mr. Garlinghouse either knew or recklessly disregarded that he was associating himself with something improper and nonetheless substantially assisted Ripple in committing that violation. So here the defendant points out that the lawsuit against Ripple doesn't require the SEC show that Ripple knew it was selling a security, but the SEC has to show that the officers and execs at Ripple actually knew what they were doing was wrong. And this higher standard makes sense because, I mean, you can imagine you go to work at a company and you're doing your thing and a month later you get sued just for doing your job. Now that's not right, and that's why the SEC has to show that Garlinghouse knew that he was selling an unregistered security. And why is the SEC not going to be able to prove that absent a smoking gun? They're not going to be able to prove it because even the federal government didn't know it. Let's read on. Looking at the middle of page 3, quote, "But it is worse than simply a pleading failure. The SEC's own allegations demonstrate that, like the market more broadly, Mr. Garlinghouse was inundated with evidence that defendants' transactions on XRP were not investment contracts, undermining any suggestions that he understood that he was associating himself with something improper. Right when Mr. Garlinghouse joined Ripple as COO in 2015, the company finalized a public enforcement settlement with the Department of Justice and FinCEN on the basis that XRP was a virtual currency, in which the company agreed to undertake remedial steps applicable to currency transactions and inapplicable to securities transactions." So Garlinghouse goes to work at Ripple, and one of the first things he gets embroiled in is some legal issues with FinCEN, where FinCEN, a department of the US Treasury, ends up finding that XRP is a currency. Repeat, the US government said in 2015 that XRP is a currency, which is the opposite of a security. And then again in 2020, FinCEN said the same thing. That's a tongue twister. And now we know not only this, but also that the investigation by the SEC took 30 months before the lawsuit was finally filed. And if it's such an obvious thing that XRP is a security and that Garlinghouse and Larsen should have known right away, why did it take the SEC and its thousands of lawyers 30 months to figure it out? And now we also know from the pretrial conference that an exchange approached the SEC and asked the SEC if XRP was a security, and the SEC shrugged its shoulders and said, "Don't know yet." But the defendants are supposed to know. Brad and Chris are supposed to know. I mean, the whole thing starts to look ridiculous for the SEC, and that's why if I was the SEC, I would make a Hail Mary at this point, because I would know I need a smoking gun, and the only possible smoking gun out there would be a letter from a lawyer to Ripple addressed to Garlinghouse and Larsen, specifically that says, "Dear Ripple execs, XRP is a security, no doubt about it, you must stop selling it." And that is why I think those advisory letters from lawyers are so important, but I don't think the SEC is going to get them, and I don't think they are the smoking gun that the SEC hopes they are. And for those reasons, I think the judge drops all counts requiring knowledge of wrongdoing. Now, I normally wouldn't say that, and I don't like to make those kind of speculations, but I really think the SEC has a big problem here on this issue, and I think the individual defendant aiding and abetting counts are out in a good way, not in a baseball way. I mean, I could be wrong, but as you know, I'm rarely wrong. And if I'm wrong and they aren't out with this motion to dismiss, I think they win at summary judgment anyway. And finally, something even more interesting to me, and something that is absolutely going to be a big issue for Ripple as well, is the final and third jurisdictional argument in the motion to dismiss, which is complicated as heck. Makes me happy I'm not a securities lawyer, but this is a big issue for the main event, the Ripple part of the lawsuit. And here the main argument is that the SEC has no jurisdiction over the sales of XRP because it failed to allege that the transactions occurred in the US. Let's take a look at page 4. And looking right under Roman numeral 2, quote, "Even if the defendant's transactions on XRP were investment contracts," which they are not, "the SEC's allegations regarding Mr. Garlinghouse's personal offers and sales of XRP likewise still fail to plead relevant transactions by Mr. Garlinghouse in the United States. This is a critical failure." And then skipping down to the next paragraph, "The SEC alleges merely that Mr. Garlinghouse has sold over 357 million of his XRP for approximately 159 million, and that these transactions occurred on various digital asset trading platforms, including 2 platforms that were incorporated in the United States and one with its principal place of business in New York." So remember, keep in mind that the SEC amended its complaint, added those facts in that were just read to you, knowing that it had a problem and was going to be facing this motion to dismiss. And I'm not sure they added enough facts, and that's what the motion to dismiss is going to allege. They do add that 2 of the platforms on which the sales took place were incorporated in New York, but that is not what the law says is important. Read on. Looking at the last paragraph, quote, "The SEC cannot save its pleadings by arguing that Mr. Garlinghouse's offer or sales are domestic simply because either he or XRP purchasers, the location and identity of which Mr. Garlinghouse was unaware, may have been physically present in the United States at the time of the transactions." And going down a couple more sentences, quote, "The Morrison analysis turns on where security offerings and sales take place, determined by where they become irrevocable," quote, "not where the principles of those transactions reside." So there you have it. The law requires that the location where the sales became irrevocable be in the United States in order for there to be jurisdiction, and that is not alleged in the lawsuit. The counter argument could be that a trier of fact could infer that it was irrevocable in New York, and I don't honestly know how I'd rule on this one. It's interesting, but I would like to see the SEC's reply letter before I give an opinion. But I think it's very important to the Ripple lawsuit as well, because I hope to see Ripple fight each and every sale on this basis with this argument. Does a US court have jurisdiction? That will be a mess, and messes are generally good for the defendant. Ask OJ. In any case, that's it for me, and thank you so much for putting up with my legal geek out. My sincere hope is that you also have something in your life that gets you so excited that it pulls you out of a hilarious Between Two Ferns episode and makes you want to talk about it. Good night.